October, the warrant of arrest, the J50, bearing the name Kelly Khumalo, was not part of the documents that were...
No, it wasn't, my lord. That statement was made in November, and the application for J50 for Kelly Khumalo was made at that stage, my lord, November 2020.
Le ncwadi ebe ucela ukugunyaza ukuboshwa kuka Kelly Khumalo beyikade ikhona na ngalesa sikhathi wenza le statement cha le statement isiyenziwe ngo-2020 le ncwadi yona iyenziwe ngemva kwalokho.
Thank you. May I proceed to establish from your brigadier in terms of the discretion. Did you take any discretion to stay or not to apply for a warrant of arrest against Kelly Khumalo?
No, I did not, my lord. As I indicated, it was this case, this matter was a procedural driven investigation. Now, prior to the application of the warrants that was made on the 23rd of October 2020, I've indicated in my evidence in chief that I made presentations, or not presentation, a memorandum to the DPP, where the not helping one, where I indicated all the evidence that we have on all implicated people, including Ms. Kelly Khumalo. She is there. A decision was taken at that time that these are the people that must be indicted, and that is accused 1 to 5. I cannot disclose further details in terms of our discussion with the NPA, my lord, but there were certain things that needed to be looked into insofar as Ms. Kelly Khumalo. Then the following month, when we have covered some more grounds than then, that's when now I made a presentation again to say this is where we are and we're making this proposal.
When brigadier uye wathatha isinqumo noma wacabanga ngokuthi mhlawumbe le ncwadi le ebunyaza ukuthi uKelly Khumalo aboshwe ingahle iqhubekiswe na uthi cha angizange mina nyenze kanjalo, mina bengikade ngiphenya lelicala kulibele kuphenywa yonke into futhi ithema kuqedwa kulayi ukuthi mina ngiyengaya kubaphathi babashushisi ngiyofaka isicelo sokuthi nabo abamangalelwa ekuthi mina nginabo nginokufakazi nakubo ukubandakanisa naye uKelly Khumalo la ukuthi ke bona abashushisi baye bathi naba abantu ekuthi bakwamele bashushiswe okwamanje njengoba kungakaqedwa uphenyo yena ubrigadier akazange athi abushushiswe labantu uKelly Khumalo yena aye.
In the light of the fact that of the evidence that accused number 2 made 2 confessions, one before Colonel Rapadu and the other one before Magistrate Mrs. Cronje, was it also your discretion that it was not necessary for accused number 1 to be taken before another magistrate after he has made a confession or the alleged confession before Colonel Mboto?
No, my lord. I think I've explained this part. So the magistrate part for accused number 2 came as a result of a 105A communication between ourselves and the state prosecutors. That's how it kicked in. I was satisfied with the confession that was made because it missed the merit. It's a commission officer, he's a justice of the peace, there was a confession. Subsequent to us engaging with the attorney for accused number 2, and in discussion with the plea bargaining with the state, it flowed from them, and then there was this confession for accused number 2, which was not the case with accused number 1.
Awuzange ke ucabanga ukuthi ummangalelo oqala naye bebamele ayiswe ayoyenza ayogunyuluka phambi komantshi njengommangalelo wesibili. Uthi ngemva kokuthi bese sesikhulumisene nabashushisi kulayi ukuthi ummangalelo wesibili bese sesiyesathatha kwaxoxwa futhi njengoba bekayenze nalesi sicelo sokuthi yena kube ufakazi kugcine seyikuthi unikwa isigwebo esingaphansi. Ngemva kwalokho kula ukuthi siye sathi sanelisekile ukuthi umangalelwa uqedile ugunyulukile bese kwathathwa ke nalesiya sinqumo sabona ukuthi naso umangalelwa woqala ubekade egunyuluke kumuntu onayo imvume yokuthi angalalela istatement esifana nazo lezo lo muntu ngikhuluma ngaye uKenneth.
Thank you, Brigadier. I'm well aware that such an engagement was done between the representative of accused number 2, as you say. But I just want to get into the point of accused number 2 being represented. The evidence, according to the state, is that the said person on the 24th of June 2020 was present when accused number 2 make a confession or the alleged confession. Secondly, the evidence that the state has is that the same attorney also participated in the plea bargaining agreement, and to the extent that such a decision or such a plea bargaining agreement was not concluded or finalized.
So
the question.
Must I comment?
Yes.
What is the question?
I just wanted to ask a question. Throughout the involvement of Mr. Meyiwa, the alleged Mr. Meyiwa, firstly, before I proceed with the question, was the agreement concluded, the plea bargaining agreement, in terms of section 105, capital letter A?
My lord, yes, it was. So there was. It was not only Mr. Meyiwa when the 105 capital A was involved. There was also another advocate who came on board. I mean, those are the issues that are because they form part of the discussions. And there was proposals and affirmations of standing with the confessions that were made by accused to the magistrate and Lieutenant Colonel Rapad. And the proposal of him testifying against his co-accused for a specific sentence, which we were of the view as the state that we are not happy with that sentence. The deadlock, it was concluded, because there's a formal communication, it was concluded the difference was on the proposed sentence from the defense side in terms of what accused 2 is prepared to do in relation. There was a specific sentence that is sent to us and said, I'm prepared to serve this sentence and in this manner, and then in return, I will testify against my co-accused, etc., etc. So it was formal and finalized.
Yebo bekuye kwaqedwa inkulumo phakathi kwabashushisi amaphoyisa nommeli ummeli uMjiyapha kusiyana yedwa khona omunye ummeli into bengikade ngingafuni ukuyiveza kodwa ngoba seyabuzwa nakho ke kwamele ngiyiveze ukuthi siye sahlulana nje uma sesekufika kwisigwebo lesi umangalelo wesibini wayekade ethe yena uzimisela ukuthi angasiya ejele noma ahlale endaweni ethize noma ahlale kanjani leso sigwebo leso kula siye sahlukana khona futhi umangalelo wesibini yena bekathe uzimisela ukuthi angayenza leso sigwebo bese uyabuya abe ufakazi ngombuso afakaze kulento ukuthi abamangalelwa abane laba abanye bayenzile kulo lecala.
My lord, it's also prudent to mention that in this communication, I remember one document, he clearly admits that he stands with the 2 confessions that he made. And these discussions, my lord, were taking place after the matter was enrolled. It was not discussions that took place before the first appearance on the 27th of October 2020. While the matter was going on, after the first appearance, second appearance, those discussions were taking place so that one can decide where he must be placed. That is why at some stage the court would have seen that in the occurrence book he spent also a lot of time in police stations, because there was these discussions, and it was put by I think on the first appearance, the request was made by him in court. Mr. Mchololo was there for accused two to be kept at the police station. It was because there were these part of discussions that were taking place confidentially.
Futhi le inkulumo lezi ziyenzakele leli cala liselingenile enkantolo, akusukuthi beqalwa ukuthi abamangalelwa bavele enkantolo bese sekulibele bevile enkantolo. Ingakho ummangalelo wesibini yena uNtanzi wayelibele ebekwe esitokisini samaphoyisa isikhathi esiningi, futhi uthi nommeli uMshololo wayekade ekhona ngalesikhathi uNtanzi eyenza leso sicelo. Akusukuthi bavele bayicabangela ukuthi uNtanzi yena angafakwa nabanye esitokisini kungenxa yokuthi bekusakhulunyiswana.
Thank you.
Once again, we just want to sound a word of caution to my learned friend that in terms of section 105A, if there's a proposal, a 105A proposal, if it falls flat, reference may not be made to it in any other manner, but if he elects to elicit that information, he does so at his own peril.
Umshutshisi ucela ukucebisa ummeli omngomezulu ukuthi le mvumelwano leyana noma le yankulumo akusiyinto eyikuthi kungahle kudingidwe ngayo, kodwa uma ingabe uyafuna ukuqhubeka lapho angahle ahlabele emgaqo.
Thank you, my lord. I'm not intending to get into the gist of.
Oh, you're not disputing it.
Now,
It's one matter to not intending to get into the gist of it.
not that I'm not disputing
Okay,
it. Not that I'm not disputing it. My, in fact, I'm concerned about the representative, the legal representative, or the mandate that Mr. Mjiako alleged to have been given by accused number 2 to represent him. That, according to you, Brigadier, is there any power of attorney that was furnished by Mr. Mjiako?
My lord, I don't think I have authority to ask him to show me the power of attorney. When I met him on the 23rd, the first time, 23rd of June, after I was informed that there's a gentleman who is saying he's an attorney for accused number 2. I don't know how they communicated. I went there, my instruction, and I've said this in evidence in chief, my lord, that I said they must allow him, despite the COVID regulation, because it was a legal visit. I arrived, he identified himself, gave me proof from the LPC, which I verified, and later we get a confirmation from people. Other than that, my lord, I don't think I could have taken it any further. I don't think I have authority to say, give me the power of attorney. All I wanted to know was to confirm when I arrived, if he was legally, if he was indeed an attorney, that was confirmed. And subsequent to the proceeding that followed, I was convinced he was an attorney, my lord, because like I said, he appeared numerous times on this matter from the time of its inception, and subsequently in Pukeng as well, my lord. And then thirdly, the discussions in terms of section 105 with the state and with the advocate that he appointed at that time, my lord.
You don't want to disclose the advocate?
I know the surname was Butelezi, my lord. I remember the surname was advocate Butelezi.
Okay.
Uthi ke wena ke brigadier ubona ukuthi ummeli lo uMjiako wayekade enalo ilungelo na lokumela ummangalelo wesibini. Uthi mina anginalo lelo gunya lokuthi ngimbuza ukuthi unalo ilungelo. Ngitshelwe ukuthi kuthwa uthi uzomela uNtanzi ngathi abamvumele ngenxa yokuthi bekunale labhubhane lo COVID-19, ngathi abamvumele. Nami the mangifika wanginika ke incwadi ebonisayo ukuthi buya khona kubaphathi bama lawyer, waphinda futhi ngambona futhi nasenkantolo kulo leli cala leli, futhi nasePhukeni ngambona. Nangokho bekungasuyena yedwa lo munye owesibini angilazi igama lakhe ngazi nje isibongo sakhe kwakade kungowakabuthelezi.
Lastly, my lord, also I've indicated that on the 23rd, as I was approaching when I arrived at the police station, it is accused number 2 who first stood up and said, "This is my attorney," to me. Secondly, on the first appearance, because I was there, it was asked, accused 2 confirmed that he, Mr. Mjiako, is his legal representative. It's on record, it was televised, my lord, it's there.
Futhi ke enye into yesibili esemqoka uthi ithe yena mayifika lapha esiphoyiseni kulayo ukuthi umangalelo wesibili uyena watshela ubrigadier ukuthi nawu ummeli wami futhi nayiqala uma lingena enkantolo belikade liboniswa nakumabona kude umangalelwa wesibili washo nakhona ukuthi ummeli wakhe uyena umjiyako.
Sir Brigadier, with due respect, if the court were to grant us leave to produce the clip, accused number 2, you were present, and he instructed me that when he was addressing the magistrate to the effect that I don't want this attorney, Mr. Mjiako responded, the presiding officer said, "I can't listen to you if you are represented." Did you observe that, sir?
Not only, but that's not true, my lord. I was there, that's not true. Like I said, Mr. Mcholo was there, the state advocate was there, number of people were there, journalists were there. There is no way where accused 2 said in that the first appearance that he does not want Mr. Mjiako. That's absolutely not true. That's why even the request of where he must be incarcerated came through the attorney, Mr. Mjiako. And accused 2 moved with us for that incarceration during that time. So that is not correct, my lord.
Manje ke uthi ummeli uMngomezulu brigadier akusiqiniso lento ewuyishoyo ngoba ngalesa sikhathi ummangalelwa evela enkantolo uye waphakamisa isandla wathi yena akafuni umjiyako kodwa umantshi wathi ngeke ngikulalele wena Ntanzi ngoba unommeli nangokho ummangalelwa besisekathe yena akamfuni umjiyako futhi naye ummeli umjiyako uyena owaqhubeka efaka nalesi sicelo sokuthi ummangalelwa athathwe ahlaliswe endaweni yakhe eyedwa futhi uthi bebakhona aba umshushisi wayekhona uyaphinda futhi uthi nommeli umshololo wayekade ekhona neindatheli zazikhona ngalelo langa ayikho lento yokuthi umantshi wathi ngeke alalele uNtanzi ngoba enommeli uyakuchitha lokho ubrigadier.
Mr. Mngomezulu, I hear you saying you're thinking while there, no. Maybe it would be necessary for the clip to be played. Did I hear you correctly, sir?
That's correct, my lord.
No, but the law, does the law allow it? Remember, those proceedings were nullified. Now the question is, are you saying the proceedings in the regional court are not part and parcel of the subsequent proceedings which inured before my colleague?
My lord,
just listen to me, because
yes,
you can think it's something simple. So if the proceedings start from the regional court,
yes,
and then they are postponed in terms of section 72C to the High Court, those are the same proceedings. And when subsequently there's a plea and the proceedings before what's my colleague's name? Right. Sorry, yeah, thanks. Mr. Judge Maumela, they proceed. And subsequently, through an order of this court, before I was appointed to take over the matter, they are nullified. Are you with me?
I'm with you, my lord.
Can you have the right to think aloud, like you are thinking, to say that tape of the first appearance in the regional court must be played? I don't think so. Me.
May I
What
be?
do you think?
May I be afforded an opportunity to
To check the law.
check the law, my lord? Then I'll make proper submissions. I'll be guessing.
Yeah, me, I'm certain The proceedings didn't be. That's why, for instance, section 337, you can quote the record of the regional court in the High Court. For instance, the bail application.
Yes.
When you argue bail application in the High Court, in the district court or the regional court, that evidence of the bail application is admissible in the High Court, meaning that, in my view, those are single proceedings which commenced when the accused were indicted and appeared in the regional court. What do you say, Mr. Baloyi? Let me hear your wisdom.
Well, our view is that the proceedings that were set aside are the proceedings that served before Judge Maumela, and the proceedings in the lower court, in the district form, stand separately from those proceedings in the High Court. In fact, the charge sheet was not even handed up at that stage. So it was only the indictment and the evidence that was laid before Judge Maumela that were set aside. The proceedings in the lower court did not form part of the proceedings in the High Court. The charge sheet was not handed up.
Okay, who wants to address this matter? Let's hear Ms. Mshonolo. Any view?
My Lord, I confirm that the proceedings for the magistrate court did not form part of the proceedings which were before Judge Maumela.
Okay.
Therefore, we can still make references to that record.
Okay, Mr. Khumalo.
Thank you, my Lord. We can still make reference to that record.
Mr. Mnisi, you were the big prosecutor in the NPA. Formally.
I share the same sentiment.
With them.
Yes. Thank you.
Okay, me, I'm making a ruling that is not so. They're the same proceedings. Go and check your law. The same accused were arraigned before a magistrate. In terms of section 72C, those proceedings before the magistrate under the same docket, under the same indictment which is subsequently drawn by the NPA, the Director of Public Prosecutions. They are superimposed and promoted, and continued before my colleague. That's why, for instance, anything that happened in the regional court, you can refer to it like Mr. Gomezulu wants to say. For instance, if there was a dispute about the bail application, he said this, he didn't say that. The record of the proceedings in the regional court are applicable as evidence also in the High Court. Go and check section 337. Is that not so, Mr.? Is it 337?
That's correct.
Just quote it.
Yeah, well, as you mentioned, my Lord, our view is that the proceedings in the High Court starts with the service of indictment in terms of section 144. So it's a completely new process that starts in the High Court. The Director of Public Prosecutions draws up an indictment as well as a written notice for the accused to appear in court. It's served on the accused in the lower court, and he then appears in the High Court on a new indictment, and the proceedings then commence in the High Court.
Okay, my ruling is that they are not. But if anybody who thinks I'm wrong, you can proceed as if they are part of what you say are the present proceedings. I don't want when it goes to the SCA, where there are several guys I've trained, you'll say, I will charge you.
And the court visits.
Okay, so you can decide otherwise, but I'm making a ruling that they are not part and parcel. They are part and parcel of Maumela's proceedings. And those were set aside. Set aside. That's why when I came here, you can recall, I said we are starting de novo, and you've got a right to apply for bail. You remember? I said that.
Yes.
Thank you. Yeah.
Indeed, but
okay, let's
yes. Yeah, just the final point that I want to make.
Yeah.
Because remember, the accused appears in the in the lower court, in the district court, before this magistrate. And at that stage, my lord, there were no the magistrate there, there were no problems regarding those proceedings. The only proceedings in respect of which there was a problem, my lord, were the proceedings in the High Court, in respect of which, my lord, in our submission, the proceedings in the lower court did not form part.
Okay, fine. Yes, Mr.
With the guidance of the court, I don't intend to be long, but it is true that the proceedings that were before, I'm sorry to state here. It's true that the proceedings before the Honorable Judge Maumela were nullified. However, in this very same trial that we're busy with here, we continue to refer to charge sheets that came from the regional court. For instance, I refer the court to Exhibit E.
No, I agree with everything you're saying.
Yes.
Except that in law,
Yes.
all those proceedings were nullified. I even tried to say, look at section 337. What? You just read 337.
337, my lord, if I were to help.
Application that evidence in the lower court.
No, 337, my lord, has got to do with the estimation of an age of a person.
No, sorry, you're not 3.
Yes.
What's this 3? Just check that. Bail application, section 60.
It should be around 60s. So.
No, but it's the transposition of proceedings in the regional court, making the bail application proceedings applicable in the High Court. You have it, sir? Got it.
Quick look. Yes, I'm aware of that provision that says
Read it.
the bail proceedings form part of the subsequent proceedings.
Yes.
I'm just looking for the relevant section. That is why the accused must be warned of that fact that the bail proceedings will form part of the subsequent.
Yes, you are right. You see, now you're getting it. That's why, for instance, as you say, the magistrate in the regional court, when an accused brings a bail application, he's obliged to warn that accused to say, be cognizant of the fact that when you're giving evidence regarding a bail application in this court, that evidence can be referred to and it is admissible in the High Court. Now, here comes the JP here, Judge Lidwaba. He sets aside the proceedings to which this statement that the bail application proceedings are admissible in the High Court, but those proceedings are set aside.
I found the relevant section, my lord.
What does it say?
Section 60.
What's the section?
11.
Section?
Section 60, 11B, subsection C.
Right, let's read
Says
it.
the record of the bail proceedings, excluding the information in paragraph A. Paragraph A refers to the previous convictions of the accused. Shall form part of the record of the trial of the accused following upon such bail proceedings.
Thank you. Shall.
Yes.
Don't even have a choice. Shall form part of the trial. And which trial are they referring to?
Yes. Well, any subsequent trial.
Yeah, which was, in this case, it was who? Maumela.
Yes.
Right? But Maumela's trial has been set aside. And
Yes.
in other words, you can't come and apply for a bail application,
Yes, but
Mr. Gumizul, and then tell me that you addressed the court in the regional court.
yes.
Okay?
But the section clearly speaks of the bail proceedings. There was no bail application
That's it.
in the lower court in this matter.
That's it. So what's your problem?
So our submission is that this section refers to the bail. If there was a bail application, those bail proceedings will form part of the proceedings.
Okay, fine. No,
in
fine.
subsequent
That's a good
proceedings.
exercise. And of course, it refers to the very same 5 accused who appeared in the regional court. The same proceedings, which are the same accused. They were arraigned in the regional court. Is that not so? Right. Okay, you've heard me. Let's move, please. Let's move. You say I'm wrong. Yeah.
I think my colleague is now being unfair
Of
when he says the section only refers to bail proceedings because it is
Not
him
fair.
who introduced these exhibits, the
That-
charge sheets,
it doesn't say so.
the charge sheets that are from the regional court. Then he must make an application to withdraw them
You're right.
if they are not applicable in this trial. Yes,
The charge sheet was served in the regional court.
yes.
Now, when I listen to you guys, the charge sheet was served before Maumela. No. They were indicted in the regional court. Is that not
Then the
so?
state must withdraw its charge sheet.
No, it's okay, fine.
Thank you.
But just to correct my learned friend,
Okay, let's
section
proceed.
235 was
Let's
missed.
proceed. You are saying what, and I'm saying the ruling is no. But because I can't stop you talking, you can keep arguing that way.
As a confusion, but we use 235.
Okay, fine, no problem.
le nkulumo ela ivele njengoba umthetho lana oyikuthi uyakhuluma ngebhayili futhi bakhuluma nangama-charge sheet ebekade ekhishwe laphayana enkantolo engaphansi i-regional court manje ithi inkosi yenkantolo asiqhubeke ngoba ngeke siliqede lolu daba singahle silale la sivuke nakusasa siqhubeke.
Hayi mina ngiliqedile usho kanjani? Oh, yini yeah, okay. It's an interesting thing, because it's a question of interpretation, but it's not even that. Remember, Mr. Ngomezulu, I said we'll now start arguing about which university did you go to.
Yes, ma'am.
Yes.
I remember.
You can't nullify something which started. When was the first appearance?
27.
Of the
27
On the
October.
27 October.
Yes, 2020.
When the DJP, the DOA was nullifying the proceedings before Maumela, he was wiping off the slate from the time these guys appeared in court. That is the nullity. Now, according to you guys, the nullity is just the High Court proceedings. And then the regional court proceedings are still current. Oh, madam. Okay, fine.
Just to mention, the proceedings were nullified not before the DJP, but Judge Mo.
Yeah, sorry, yes. Okay, fine. Yes, Mr. Ngomezulu, Uzwide again.
Mzwile, ma'am. My Lord, I was going to request an adjournment.
What's the time now?
It's 20 past 3, my Lord.
20 past 3.
Yes.
I'll still continue with this witness, Brigadier Sasa.
It's only a few things.
So why don't we finish? If it's a few things.
It's an AVL, my Lord, Mchiako. AVL Mchiako. Yes?
Okay, fine. Maybe you'll have to come back tomorrow. I'll tell you why. You were saying the section 105A plea bargaining was completed. You heard yourself.
Yes,
It's an agreement, is that not so?
correct, my lord.
Was it signed by both parties?
Insofar as I know, my lord, but that was between
Was it signed by both parties? Even if, because of whatever you say, there are threats made to accused number 2,
Yes.
but it was signed.
My lord, it was signed.
It was signed. Okay, that's all I wanted to know.
Yes, my lord.
Yeah. And I'm sure the copy of that thing is somewhere.
There is a copy, like I said, where I know the proposal
Okay, fine.
of these things that I'm talking about, and there's a signature.
All right.
So it was a formal engagement.
Okay, fine. Tomorrow then at 10.